Good morning, everyone. I guess they started the feed live early this morning. I can't believe it's taking a week to seat 6-person jury. Thank you. I mean, my Lord, have mercy. Now, he wants 8 alternates, though. He did say that early on. I don't know why he wants 8 alternates. I guess in case of COVID, he's probably been through. By the way, you guys, uh, my mic, if it sounds too low, please let me know. I did adjust the volume down this morning. Couple of things that I adjusted. I did that. Plus, I adjusted the ad settings. I had somebody tell me the other day that they came in and within 5 minutes they had 6 ads. That sounds a little excessive, but if that is occurring for you guys, please let me know because I do have my ads turned on. I put it on a different level. It was on balance. There shouldn't have been that many ads. So I've actually changed it today to be a little bit different and I'm curious to see how it affects everybody. If it gets crazy ads, please let me know. I've got premium, so I don't know how many ads you're getting. I do recommend YouTube Premium though if you don't have it. If you watch YouTube all the time, you might as well go ahead and get it. It's so worth it. So anyway, back to this jury thing. I get it. I get why he wants more people because we've already got one person out saying they got COVID. So then you know how that works. You get one string started and they keep going and keep going. Somebody else will come back and say it. I tested positive. I wonder if they have to show they tested positive. I mean, sometimes people just want to get out of jury duty, right? You never know. So there could be that. Am I having Pop Tarts and juice? No, I'm having a big, huge cup of coffee. Coffee with lots of cream, no sugar. I've got all the sugar I need, honey. I don't need sugar in my coffee. Long Crime is already live at 8:45. I know, I don't know why. I have no idea why they went live so early. Did you guys see, if y'all weren't here last night or yesterday, after they got done with the hearing, we stayed on and we were watching that portion of Sam and I's video on the different BSS cases and whatnot that we were comparing because we were looking at the case laws. And Trial TV Live was able to get a live feed in the courtroom. They got permission. So we ended up watching, I think most of you guys were here, but we ended up watching the part of the jury selection yesterday. It's on my live stream from yesterday, and I did finally go in and timestamp it. So if you want to go check it out, hopefully the same thing will happen again today. I don't know. We'll see. It might be a little different today. I think yesterday afternoon, we ended up where the state had finished, I think, most of their questioning the jury, potential jury. And I want to say they might have a little bit more left. Or if they don't, they're going straight into the defense questioning the jury in the morning. It was interesting to hear it and to hear the different ways that they're approaching things. Of course, they're asking about, anybody have ever been involved with domestic violence, you or anybody you know. Then they get into the whole, he went into, what was the questions he asked? He even asked about people that had anxiety and if they took medication for it. It's either you or somebody you know. Then he asked about, like, couples getting, one of the things he said was, do you know any couples, or have you ever been in a restaurant and then like a couple you don't know, they just start arguing? It's kind of uncomfortable, right? What did you do in the situation? That kind of thing. It was weird. It was just kind of different weird. So we're going to go, let's just recap. Again, still on my first cup of coffee. Let's recap what happened yesterday. So as far as the battered spouse syndrome thing, hearing, motion, judge kind of left the door open there. He said, okay, look, you can't use it in your opening statements. but you can mention it. He said you can mention it in your opening statements, battered spouse syndrome, but until you prove that you have a case for battered spouse syndrome, you cannot use it once we begin trial. Which I was like, okay, how does that work? So I guess they would have to bring Sarah on the stand because they're saying it was lacking. That Dr. Harper's diagnosis of Sarah is lacking. And he said her opinion to allow, he said, what is her opinion in order for us to allow her to testify? And the judge says there's no overt act here. And an overt act, guys, is something as an act that can be clearly proved by evidence from which a criminal intent can be inferred. So, like, he made the example of if you had a biting dog. What was the other example that they gave? It was a great analogy. They said there was no overt act by George. So, in other words, him sticking his fingers out of the suitcase, the defense wants us to believe that him sticking his fingers out of the suitcase, excuse me, is the overt act. But then she beat the hell out of his fingers with a baseball bat. Uh, the defense said his hands coming out of the suitcase, and she was afraid for her life at that point because if he got out, then he was going to hurt her. I don't know. I think self-defense is absent on everything, based on everything up until the trial start, until we, I mean, there's just no, they're trying to prove self-defense. And the state said, nope, everything shows that she is clearly the initial aggressor of everything, aggressor. And the state brought up that George only weighed 103 pounds, which I was so glad they did that because I feel like they're zoning in to where we're zoning in on this, guys. I mean, it's not like we thought they weren't working on this, right? But it's good to know that we're all on the same page here. And her claiming something about, I think it was Jay said something about the night before she was claiming that he drug her up the stairs by her hair. The other thing that occurred yesterday, my notes suck. Wow. I was just a scribbling. The medical records for George. Okay. So let me catch everybody up if you have not been here. Apparently, like 2 days ago, the defense dumped on the state 550 pages or plus of medical records on George Torrez Jr. And the state came back and said, you can't do this. You can't just dump all this on us. What does this have to do with the case? Like you can say that here's the medical records. We want to insert this page, this line, whatever. But you can't just throw us 550 pages and say this is it. The defense is trying to say, well, he had all of these things were happening. They're trying to paint George as I think, an angry, violent person because at one point he had gotten into a fight with his brother, and another point, well, his brother beat his ass. His brother beat him up. But another point, he had put his fist through a window and broke the glass, and so he cut his arm or cut his hand, and he had to get stitches. And there's like 487 pages where he had to have, I think, jaw reconstruction or something from his brother beating him up. And they want all that to be included. And so the state is saying, look, we don't care if you want to bring in that he got into a fight with his brother. That's fine. But we don't need to see everything, all the details about his surgery and the follow-up visits from his surgery. Like, what's the point in bringing that in? And so we believe what's happening is the state, it's just the defense's way to try to like pull the wool over the jury's eyes with a bunch of junk, throw a bunch of stuff at them, and maybe they won't notice the elephant in the room. I don't know. So The judge said that the narrative can come in, the narrative of the idea of his what was going on with his medical records, but those 487 pages about him being all the surgery and procedures afterwards, after he got beat up, he's going to leave that open. It cannot be brought in right now because until the defense comes back and says, show me the specific pages that you want to insert within the trial, the judge says no. Literally yesterday, you guys, it was as if Owens and well, no, mostly Henderson. Henderson is Owens' co-counsel. And it was mostly like he came in and was like, oh, hey, yeah, I haven't read the transcripts, but I want to insert the transcripts. Well, I didn't read them. I just heard about them. I didn't watch the videos. I didn't read the depositions from these witnesses, but we would like to insert these witnesses. And the judge is just saying, he's looking at him like, what, excuse me? And they're like, well, we just got on this case like 45 days ago. And they're going to keep using that excuse throughout the entire trial, you guys. They're going to keep doing it. We know this, right? How is my audio, everyone? Can you let me know in the chat? Is it too low? I know I'm usually too much. Hey, Noni signed up for a new membership. Thank you, honey. Case one I found out last night, she used to be a paralegal. Oh, my word. Show me proof, case one. Show me proof, and we'll talk about it. I don't know about that. See, that's the first I've ever heard that. That's how rumors get started, y'all. Case one, give me some receipts, mama. I'm not saying you're lying on purpose. I'm just saying, give me some receipts. Henderson is completely clueless. I swear he was like, oh, you need me to show up to court on Tuesday or Wednesday? Okay, I'll be there. Oh, are we actually going to trial? Oh, okay. Well, let me get my book out. I'll read the stuff you sent me on the way over. That's what it seems like. It's Henderson is truly treating it like I'm not getting paid for this, so I'm just kind of here. And Owens is like, dude. I wasn't impressed with Henderson. I was surprised. I thought he was going to come in and be a lot like Owens and try to woo everybody with his charisma and all that. And I didn't see any of that. At least Owens puts on a little bit of a show that way. He's got a lot of charisma, but he still talks out the side of his mouth. Aw, thank you, Noni. That's so kind of you. Noni found the super chat button, you guys, and the member button. Look at her go. You're like me. Thank you. Thank you very much for your super chat and your membership. Okay. Thank you, Laura. It's perfect. Okay. So I don't know. Have I usually been really loud? Am I usually too loud, guys? I know that I'm loud, like without a microphone. I've always been that way because I took drama and speech and all that. And I've always been one that's like, I project my voice. I can't help it. Not too loud. Okay. Thank you so much. Who has all the power and control in that home? Well, whose home are we talking about? Are y'all talking about a different subject in the chat again? Giannis said, I did not expect Henderson to be good. He was awful the first time we saw him. Well, yeah, but I was like, well, he was on Zoom, though. I was going to, like, okay, he's getting a kickstart or whatever. I expected him to be a little bit better yesterday, but so now we're going to, I guess Henderson is going to be doing the jury selection questioning this afternoon. How about the selected juror who just didn't come in? I know. Well, there was one guy that they said, I got to get y'all a parachute emoji. I promise you I will. There was one guy that said, well, I guess I misunderstood because I called the number or I misunderstood when I was supposed to come in. And because it was already so late in the day that they gave him a pass. I bet they're going to put him back on the list, though, to come back. I guarantee you he's going to get called next week. Dorothy, good morning from New York State. It's 34 degrees here, freezing like Boone's heart. I am in Alabama, and it's 46 degrees here. And that was surprising. I actually turned my little heater on last night for my cat because I didn't want her to get too cold. I feel like we didn't get any fall weather. It just went straight to cold weather because to me, that's really cold. Thank you for coming in from New York State. Since you're from New York, are you a Yankee fan or a Mets fan? I need to know these things. I'm a Yankee fan. Except I haven't watched baseball in a while. I think probably after I stopped watching baseball several years ago, but I used to watch it like crazy. Okay, so anyway, the jury stuff. I was making some notes and I'm like, why am I making notes? Because we got it right here on tape. Oh, here are my notes. Right. He said, have you ever experienced a couple have a public fight or an argument? That was one of the things that Prosecutor Jay said. And he said, what about he started making baseball player references and batting average references. And it was funny because one of the guys that apparently knows somebody that is in the pros said, well, I can get up and hit the ball. And he kind of went a little bit too detailed with the whole thing. And Jay was like, okay, whoa. Then they had an opinion based on the news society. That's right. Oh, God. They got into politics a little bit. What news channel do you watch? And he made a good point. I don't understand why he said this, but he goes, okay, so look, if you lean one way politically, are you more than likely going to watch the news that's kind of more towards that, or do you go watch other feeds of news to learn different things about it? I.e. Fox or News Nation or whatever versus CNN or something like that. And that was kind of different. It was interesting to see what people said about that. One lady got up and she was telling her, she's like, I don't trust anybody. I think they're all a bunch of she didn't say they. She said, I think they're all a bunch of crooks and they can all be bought and da da da. It was like, what? Yeah, we don't talk politics usually on this channel because I think politics divides people. But yeah, I was hoping, I'm like, please tell me this is not going to get too political yesterday when we were watching it because I was just watching the chat. I started zooming in on the chat. I'm like, where are we going with this? Because I knew y'all were going to start chiming in. I'm like, I don't want to know your political views. I'm not going to tell you mine. I don't want to know yours. Looking at my other notes here. There was mention that the evidence that was being filed. Prosecutor Jay said something yesterday about Owens is not filing the information or the evidence through the clerk of courts. And I guess it's not getting filed properly. He's not going through the proper chain of command. Because, and I think that's probably Owens playing dumb or taking shortcuts. And the state's like, you can't do that. You can't do that here. We don't play that game in this county. They started talking about the cell phone evidence yesterday, which was super interesting. That was probably the most interesting thing that happened all day. And the defense tried to say that, well, we don't know. There's a bunch of photos here. But, we don't know where these photos came, like what the dates were on them and how to, should I bring them into trial? Should I not bring them into trial? And when he said that, the first thing that came to my mind was, dude, you have a whole report. The state, I know, pulled a whole report on the cell phone, right? And as soon as he got done saying that, Prosecutor Jay walked around. He was so ready for it. He walked around. He put all the paper in front of everybody, including the DVD and everything. He goes, okay, what I have here is the narrowed down phone extractions. I've color coded it. I've alphabetized it. I've got diagrams. I've got a full PowerPoint. That's not exactly how he said it, but that's kind of how it came off, like he had documented every single photo, and they were time stamped, and he had different divisions of the pieces of the different things off of her phone. There's apparently a conversation with George's family that I'm really, really interested in hearing. Hang on just a second. Sorry, I needed some water. I think it's Mo. I think it was Mo that she was talking to. But somewhere in there it says, I'll get rid of him. I heard that. I'm not really sure how that fits into everything. But it sounded in what he was saying, it sounded as if everything on that phone is showing contradictions. I need to piece that out. I should have done that last night. And I did piece out. So I went in and I time-stamped everything that we had yesterday. So if you want to go back and watch it, at least I've time-stamped it down somewhat, because it was an 8-hour live stream. And then last night, I broke out the hearing. And then I guess I don't want to pull it up and then us miss this. So hang on. If somebody wants to, I'm sorry, I'm sniffling. Somebody yell at me if Law and Crime comes back on. I'm going to see if I can find the portion of the hearing that talks about what they filmed on the phone. That was the one time yesterday that I got up to go to the bathroom. They started talking about the phone. And I'm like, are you kidding me? I've been sitting there all day long and I missed that part. Not always the way it is. Who was it that got the Grammy or Oscar? Was it Renee Zellweger that got the Oscar? And she was in the bathroom. They're like, she's in the bathroom. Let's see if we can go to the part. Oh, shit. Okay, sorry. She's back. All right. I'm back. We're staying on this. Sorry. I was going to let us watch the hearing from yesterday. So, again, third day in a row, she's got the suit on. Different shirt. Now she's in yellow. Remember, yellow was one of the colors they said not to wear on our color psychology. They just went and got her a bunch of shirts from Walmart. They got her a suit from Goodwill and a bunch of shirts from Walmart. We're going to have to watch her sit there in that damn gray suit this whole trial. Or is that a brown suit? Or is that the same gray one? Maybe it's brown. Maybe it's a different one. Yeah, everybody said gray. I said, I think it looks brown. From yesterday, anyway. Which, by the way, if you buy your shirts at Walmart, I'm not judging, because I just got one from Walmart the other day. I bought a T-shirt that says, "We can't fix stupid, but we can give it a court date." I'm gonna have a T-shirt made up like that for our channel. It's an odd green. Is that what it is? It's not a full brown. If you know how to shop at Goodwill, you can get some good stuff at Goodwill. You got to know how to do it, though. I used to go over there like once a month when I worked in insurance during my lunch hour, just to browse and see what they got in. But you do have to work. You have to go to a good one, a big one, and you got to weed through a bunch of stuff to get to the good stuff. So if you don't have time to do that, because vintage is not always a bad thing. Her blazer is cut from the same cloth as Owen's jacket. Que sera, sera. Que sera, sera. Put state at disadvantage, not based on law. I was ready to shut off. What does that mean? Well, everything they came in with yesterday was not based on law. They're still, it's that same strategy where it's like, Judge, I'm going to reserve this to talk about this later. And instead of just saying that up front, they try to argue everything and waste the court, like in 30 minutes of court time. And then they go, well, I was just bringing it up because I want to be able to talk about it later. Well, why don't you just say that? Why don't you just say that? You think she's definitely wearing eyeliner. Well, these are important things we need to know. Judge is in the room, apparently. Nobody else is going to stand up?
William J. for the state.
Oh. Audio sucks.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
Thank you for your super chat, fan lady.
You did not.
You're cracking me up, girl. Tequila Rose, thank you for your super sticker.
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come?
Makes it very difficult to prepare for opening statements. I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I
Wow.
don't know what else to tell you. State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay. Correct. That's correct.
10 strikes.
Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling really was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Mr. Owens? How long do you think? 10, 15, 20? Okay, great. All right, we'll
15
be in
minutes.
recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that.
Yes, they
All
do
right,
need a
so
mic.
do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Okay, hang on. I'm fixing to sneeze. I don't want to sneeze into the microphone. Okay, wait. I think it went away. Okay, so if you guys don't know what's going on, or if you're confused, let me explain why the state is so adamant about this. And I'm going to try to break it down as much as I can understand it. So on the rulings that the judge gave yesterday, he kind of left two open-ended in a way. On the battered spouse defense, he denied it in part. And he said that you can mention the battered spouse syndrome in your openings, but you cannot put on a battered spouse syndrome case. I don't know if that's the piece that Jay is upset about. The other thing that he ruled on was the thing about the narrative with the medical records. And he said, you can bring in the narrative about about the 550 pages of his medical records. You can bring in the narrative of him being in a fight and the hand going through the window and getting cut, but you cannot bring in the 487 pages that are details of his surgery and the follow-up procedures and all that stuff. Well, thank you, Miss Janice. Janice said, sorry, I can't. What? Oh, okay. I understand. Oh, you do good things. Wildlife rehab facility. Oh, hon, that is so awesome. I love that. Well, thank you for your time that you do for your community. That's so special. I love that. Thank you, Janice. I'll try to keep you up to date, my friend. I'll try to break today's stuff down as much as I can before then. Yesterday we were on for 8 hours, you guys, or 8.5 hours, and I was so tired when we got done. And I had to go take a nap. And I got back up last night, and at least I trimmed down the hearing out, but I really wanted to trim some more out. We don't have time to watch the pieces that I want to watch because it's going to take too long. So that's why I'm reading this off to you guys. It said on some of the medical records, it says there's at Christmas of 2017, it said that George was jumped and beat up. We know this was Mo that did it. And we know that it had to do with Sarah telling the family that George hits her. And I thought to myself, my goodness gracious, please tell me they're not sitting around at a Christmas function and she's drinking and she brings this up and a fight ensues because of that. But I guarantee you that's probably what happened. Anyway, the state said that's irrelevant because it has nothing to do with Sarah and George's relationship in a sense. And the state's claiming that they're just trying to bog the jury down with a bunch of paperwork. In regards to the other motions that were discussed, okay, remember how they wanted to redact a bunch of the interrogations? Well, there was one piece where he said pages 53, 55, 56, and 92. He said, no problem. You can take that. We'll take those out of the interrogation. The state didn't fight that. I think the state didn't feel like that was that big of an idea, big of a big deal. So anyway, let me tell y'all yesterday. So what happened yesterday was after that thing I told y'all, we got to see jury selections. So Trial TV Live has a press pass, and they were able to get over into the jury selection room. That they went up to the 23rd floor. And they were able to give us a feed yesterday of the jury selection. Of course, the feed was basically on the judge, and then it was on Sarah most of the time. But you could hear what was going on in the background, which is all we really wanted to do, and all we knew that was going to be the way that it was, right? So let me take this down. Sorry. Jules and Chris from Trial TV Live did a live last night, and they were talking about their experience yesterday, and they said that Owens was a little snarky with Sarah, that he seemed like he was in a bad mood yesterday, and Sarah was telling him to do stuff. She was writing stuff down, and then he would take her paper and shove it back in front of her and point to the judge and say, listen. She said it was funny, but she did say that she was in the elevator at one point with the prosecution, and the prosecution knew who they were because she said, what time are we supposed to be back? And they, or, you know, and something about the time was mentioned, right? So she overheard them talking amongst themselves, and Chelsea Copsall was in the elevator with them because, she was in the morning hearings yesterday, and Owens got all flustered over that. He did not like the fact that Copsall was in there, and she's the main detective, the cough-a-lot detective in the interrogation. They didn't need her. They just said she's here to watch. I mean, they can have her there at trial. I don't know why Owens made such a big deal out of it. So apparently, Jules overheard them talking yesterday, and they said it out in the open that they didn't like the BSS ruling. And Copsell says, "Well, I need to know what's going on. So if I'm called and I'm being questioned, I need to know what I'm allowed to testify about." And so I think this is the part, it all has to do with this battered spouse motion being split up. I think that's where they want them to be more specific. They want it on the record. So I guess that's why the state is doing what they're doing. I want to show y'all something really quick. How about you? This is the juror box sheet that Sam showed us. I had to blur it out so that because it's a real one from a real trial, but it just shows you how this is kind of like what both the prosecution and the defense have, and you can see where they've clearly marked out the jurors and stuff. So that when they get down to the point where they're at now, they make their notes on there, on each box, on each juror, and then they just kind of check them off as they go. Last night they were dropping like flies in the afternoon session because you could hear when they would come back with their answers. We're like, oh, that person's going to get taken out. That person's going to get taken out. Cookie said, y'all think they're going to claim 2 fingers sticking out of the suitcase is an overt act? That's what they said yesterday, Cookie. Henderson said this. It was clear that his fingers sticking out of the suitcase were proof that he could get out of the suitcase. And she knew that once he was going to get out of the suitcase, that he was going to come after her. That's how he put it. So, yeah. I know. I know. I agree with you. I'm with you. But thank you so much, Just Another Smith. Oh, hard work on this case. Deep diving for all the details. Thank you. Thank you so much. And thank you for noticing. I appreciate that. I try, y'all. I try. Oh, I missed it from Emily. I'll get back to you, Emily. Hang on. Yeah, I'm doing my best to keep up. And you know what's crazy? I don't know about y'all, but so this is the first case that I've really paid attention to the docket from the beginning, from start to finish. Usually I go into a case and it's like, okay, let's watch the trial. That's just me. Like, I know the details of the case from the most part from watching court TV, other documentaries, but I haven't really gone in and read what's on the docket. I haven't gotten into the legal side of it, right? This is the first time I've actually listened to what's going on. We've had Sam on, and she was giving us a lot of great items and tidbits that we were able to learn, not just from her side of being on the investigation side of the defense, but also her legal knowledge because she does have a legal degree. So it's like, or law degree. So it's really interesting this time around for me and just learning all the more about how trials work. Like I didn't know anything about the JAC before going into this trial or going into this case. Now I totally get it. I totally understand pretty much not everything there is to know about the JAC, but I know a lot more than I did before. I never even knew it existed before. If you asked me a couple of questions, I could probably answer them at this point. You know what I mean? So that's interesting. Thank you again, Just Another Smith, for your super chat. And I love your name. That's so cute. And Emily, Miss Emily, thank you and happy Friday Eve to you too. And yes, hashtag justice for George. So let me look at y'all's chats and see what you guys got. It's been really cool. Let's see, to watch you learn. Oh, thank you, Yana. Yana's like, yeah, we know, Carrie. We've been trying to teach you. And Mark knows because Mark's been here from the from the beginning, and he said, "You're doing a great job with the trial, Carrie. We appreciate all your deep diving commentary." Thank you. Court is back. Y'all, I'm live. What do you mean court's back? What you talking about, Amy Crew? We're live on Long Crime. They're still not showing it. Amy Crew. Never mind. I'm wrong. Psych. She said psych. No, here they come. I did see something come up, though. Let's see. Scout November Light. What a cool name. And I'm looking at your different photos. That's cute. Your picture says, "Hope y'all all ready with your 5 peppermints." I know I am. I did. I went out and bought my 5 peppermints last night. Yes, I did. I'm just kidding. Got no damn peppermint. Did everybody put in their order for their Pop-Tarts this morning? Okay, why am I seeing the coverage on my phone and I'm not seeing it? Because my phone is not live. Okay, that's irritating. The electronics are messing with me this morning. Scout, where are you coming in from? Is that, it's not a regular dollar sign. What's going on? What? So you're not in the US. Where are you coming in from? Let me know. I think what we're going to do next after this case is over, you guys, is, yeah, I'm still on copy too, Jeannie or Millie. I want to go into that Courtney Clenny OnlyFans model and start diving into her docket. That sounded so bad, but it's true. What kind of snacks do you guys have? Oh, you're in the UK, from Sweden originally. Oh, wow. That's so cool. That's so cool. We can grab the liquor later. We might need liquor later, you guys. Jeez, my knees. I mean, it's funny because we've been talking about AA and stuff since this trial started because of what it's all about. And it's amazing to find out how many people in here are recovering alcoholics. It amazed me last night listening to, I keep saying last night, yesterday afternoon, listening to the pieces from the jury selection, how many people either were affected by alcoholism in their family, they themselves, somebody they knew, and then also the next step was domestic violence. They themselves, someone in their family, or someone they knew. And I kept thinking, wow, our potential jury, they're dropping like flies over there. Everybody was connected to something somehow. Or you know what I didn't do because we were watching it? I did not go into Twitter and find out exactly what it got narrowed down to yesterday. I don't think it did. Did anybody look? I'm going to open Twitter right now and take a quick look. And see if I can find anything for you guys. Because before that, we were. I was getting all the deets about the jury selection. But since we watched it yesterday, I didn't. But they didn't dismiss, to my knowledge, they didn't dismiss any jurors yesterday because they're still going through them all. Because the defense now has to come in and ask their questions. Hi, Leah. You weren't in chat when you were discussing the actresses to play Sarah yesterday. Was cracking up on the replay. Renee Zellweger would be perfect to play Sarah, and she's 5'4", so she's the right stature too. Her or Megan Mullally. Somebody said we like the idea of Maggie Gyllenhaal. Is that her name? But she is too tall. Somebody said. You're right, Casey Russell. They didn't let anybody go because they still have the questioning going on. You guys, please give some love to Bama and Laura for being here and keeping y'all in a safe space. Billie Jean says if she went to bed scared George would come after her, doesn't she think that he would come after her when she woke her? In her sleep voice text spelt George wrong. Thank you for all your hard work. Yeah, like if you're scared, do you really go back to bed or do you leave at that point? You've got him in a suitcase, so get the heck out of there. You got your car keys, you got everything you need. You could have left. Is that where we're gonna be, you guys? At the end of this trial, are we gonna be sitting here looking at just that? Is that gonna be what's gonna be the qualifier? But it's after everything that we've been huffing and puffing about while we've been preparing for this trial. The jury's going to be sitting there and they're going to say, well, that night she had the chance to leave if she wanted to, and she didn't. She stayed in the house, which told us that she knew he wasn't going to come out of that suitcase. Or, are you guys, do you understand what I'm saying? We've sat here and we have dove into this case backwards and forwards, trying to find the angles. Where's everybody going to be coming from? What's going to happen? And the jury's going to say, yeah, she could have just left. I do a great impersonation of Sarah. Thank you so much. No, wait, I don't know. You know what's funny is I got to stop listening to that stupid interrogation, because yesterday I was making comments and I was listening back as I was editing it out. And I thought, oh my word, I'm starting to sound like Sarah, talking like she does, making the same comments she does. You guys are so nice in the chat. Wow. Who's paying you guys to say all these nice things? How much are you making? Please, if you don't mind, y'all, make sure you hit the like button on your way in or on your way out. It does help me tremendously. No, it doesn't count if you like it twice. But thanks for trying. Keep in mind that the jury will not see. Exactly. And Michelle, that's just it. Like, that's what I was thinking about yesterday. We've got to go into this with the mindset that there's going to be a ton that we know, because we've been so involved in this case for well, it's been going on for 4.5 years. I know on my channel, my deep dive started back several months on it. But what is the jury going to have? What is the jury going to truly be able to see? We're going to have to keep that in our mindset and not what we already know about the case. So we're not questioning the things going on. Very, very well said, Michelle. Yeah, she called the police on him, Zombie Girl, for pretty much anything she could. It's like Sarah was bored one day, so she calls the police. Sarah's not getting enough attention, so she calls the police. Jean said, battered spouse syndrome is allowed as a defense, but in my opinion, George is the true battered one. And I'm going to tell you right now, don't worry, Jean. I think what's going to happen is the state is ready for that. Because like I said earlier, when he mentioned George's size and that he was only 103 pounds and that Sarah was clearly the aggressor, the initial aggressor, the state is in it with us. They are on our side. They are in the thought process of all of us here. So this is good. All right, when we get audio, I'm going to shut up. We don't have any yet. That poor court reporter. I wonder who that is in the back there. In the gallery. That's not Copsel. Her hair's too long. And she was sitting way far away from them on the other side by the window the other day. Yesterday. Oh, Angela S. I'm a retired homicide detective of 20 years. I have sat as advisory detective witness at the state's table numerous times. You are doing great, and I appreciate how you ask for proof on everything. Ah, cool. Thank you so much. That means so much to me, knowing that you have all that experience and you still think I'm okay. Thank you. I question myself a lot. Thanks, Angela. I appreciate you. Yeah, Emma. Emwa. She could have, once she got him in a suitcase, the thing would have been to call 911, left the door unlocked, called 911, and
We're
said,
back on the
go.
record.
Go get
Case
him.
number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state. Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much.
He hadn't done anything
That
until
cures
now.
itself. Counselor?
There he is.
Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Yes. Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir. Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Thank you, Blanco. God knows we need that fund. I was wondering who was going to support me on that fund. I knew you'd come through for me, my friend. Oh, Donna, thank you for being here so long yesterday. It was a long day. I was so tired. I didn't even eat lunch. I had peanut butter crackers. I've got to start getting up and walking around while they're having jury sessions or discussions so that I'm not sitting at my computer the whole time. Why is he looking at this with her? I swear I think he's placating her. Isn't that the word
Okay.
that I need to be using? Placating her?
All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA 1971, Reed, R-E-I-D versus State 213 Southern 3rd 1110 at page 1111, Florida 5th DCA 2017, Rudin versus State 182 Southern 3rd 724 at page 726, Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 Southern 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just understand, put it on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from someone.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point for the record for the 6th DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or diet nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, not yet received by the defense, it's not yet received by the state,
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, the defense committed receivable discovery exhibit.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that.
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the admin report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them. So we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages evidence?
Their medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it was corroborated. Her testimony that she suffered an injury at the hands of Jorge Torrez.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
My understanding is the first 81 pages were medical records of Sarah Boone that we had gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break and let me find out from my secretary.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3, is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday, regarding the blood alcohol content records and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on a response.
Too late. Too late. Oh, well. Can't use them.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225, Goes through alcohol abuse, yes. Type, spirits, not wine. Last used, 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. It's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing this exhibit into evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper, if she has not reviewed these records yet? When do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take another deposition. So I'll wait. I will not ask her to review.
Okay. State with,
That was the only purpose.
okay. So state understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts. Does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail.
Okay, the objection is sustained. 18, prior criminal history of Jorge Torrez not yet received by the defense. Has the state received that?
Other than the arrest history that's resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, and Massachusetts. We're not referring to that as well. We're referring to the one involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah's testimony about her injuries, photographs, officer physically observing injuries on her. That's the nature of this. So I don't think there is going to be anything about prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I assume Dr. Crumble will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. Her family can't help her, she has no group. The state attorney dropped 3 of the charges. 3 separate times George Torrez was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Wood says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torrez when she was.
But that all sounds like oral testimony. And again, this goes back to, this is an exhibit list. What are the exhibits? Tangible, physical?
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torrez Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
Has to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torrez. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one.
We don't introduce anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Brian Boone, we anticipate is going to testify for the state, he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel. Sarah Boone does not have that force.
What does
Based on
the,
what he says,
what does the non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation or, and I don't know because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach just for a moment?
I think the judge right here is finally calling out Owens and the whole defense team.
Right
Oops, I hit my
here is
phone.
fine.
On this sidebar. I'm wondering if that's what this is about. There's too many things that he keeps bringing up that, well, we don't have that piece of it, or we're getting to that, or we haven't done this, or we didn't realize you'd need that, and we thought the state knew, and there's too much of that going on. And the judge sees what they're doing. He's not stupid. Bet you money. I wonder about, so they're saying that Brian has not paid alimony. He hasn't paid alimony because according to the records, the judge ruled that they were going to address this, I thought, once they found out what happened with her sentencing here, or what turned out here in her criminal case. And I don't see how, I guess they're saying if he gets up there and talks bad about Sarah, the defense is going to turn around and say, well, you want her to go to jail because you want her to, you want her out of your life. And then if she goes to jail, you won't have to pay her any money moving forward. That is opening a whole new can of worms, I think. Yeah, no doubt, Heather. No doubt. I had seen before, I think, where they had moved up north and I'd kind of left it open. Like every time I saw it, I think one time I mentioned it and I caught myself and I was like, shh, don't do that again. But now he's put it out there to everybody that's watching the trial of where they're located, which is so unfair. To her son. She doesn't give a crap about her son and what he's been going through. She, everywhere she goes, she leaves people in her wake. She is just one of those type persons. So I wonder if that's going to be a problem, you guys, where they're saying that on the police reports and the work reports and stuff, that all these reports from the police department, whatnot. I hope they're looking at that closely because I feel like the defense is trying to slip something in there because they're saying we're not going to use those as evidence, but if the witness on the stand needs to reference anything in those reports, they can. That's just, yeah, it's just like Sam said. They're just dumping at the last minute. They're dumping all this crap on to the state. And I almost feel like there's no telling what they're trying to pull in while they're doing that. It's like, watch this hand over here while this hand over here slips this in, you know? Oh, she is a parasite. Just, oof. Just ridiculous. CB, they're just pathetic. I agree. Hey, D. Hogan, thanks for becoming a member. Oh, you look pretty today, Sarah. I just wanted to tell you. Cater to her. Owens is like, she's getting pissy. Go over there and give her some attention. Get her off my back. I'm trying to do something. Distract her. Oh, they're friending. Isn't that sweet? Hey, can I be your friend on Facebook? No, that wouldn't be possible. I don't think so. I think after this case, I'm not going to be able to talk to you anymore. Loba says about the parts redacted from the police interview. Can the DA ask the detectives when on stand about those comments? Yes. Redacted from the police interview? No. I think once it's out, it's out. And they said, you're referencing the pieces where he goes, well, you realize you killed him. And she's like, I've thought about that. That's one of the statements. There's some other statements in there too, which again, we'll go over that when we have a pause here in a moment. It would be a good document to look at today. But no, if it's pulled out, it's pulled out. That is my understanding. Now, if there's anybody in the chat that knows for a fact that I'm incorrect on that, please call me out and tell me. Miss Pensacola. That's a good one, Mark. Mark W. He's giving our other Mark a run for his money on the comedy in the chat. You want to go for drinks after we're done, Sarah? No. Watch Sarah get up on the stand and talk about being in recovery from being an alcoholic. She's going to do that.
For your arguments and clarifications based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo.
I need
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Any or all exhibits previously listed by the state?
Mhm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so practically he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the 6th Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torrez in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, Jorge Torrez, George Torrez, died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's answer. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Warner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Warner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
I don't know about you guys, but I'm a little bit confused. Yeah, the videos will testify. You don't need a witness for that. That's a good point, Miss 56. The community needs to be protected from Sarah Boone. Absolutely. Yeah, if you guys don't have your snacks stocked up, y'all need to get ready because we're fixing to go to trial here. All right. So I'm confused about what they were saying about the BSS, the battered spouse syndrome. He's saying the state didn't disclose their overt act and we had to give ours. They made us give it, Judge. They made us give it, our whole case right in front of everybody, right before trial. Do you know what their case is, you guys? Their case is that he could get his fingers out of the suitcase, so he could get out of the suitcase. George could get out of the suitcase, and when he did, he was going to come after Sarah and hurt her. And that is their case. That's their case. Really? Really? Did you guys catch that we're not going to get the 911 calls? They're not going to introduce those. We already have the 911 call from when she passed or when George passed. We just didn't have previous incident 911 calls, and I was really hoping to hear those. Then he said something about the state putting in the news footage of her being transported in or being taken to the police car. I know exactly what footage they're talking about. You guys know when they pulled her out of the interview and they escorted her to the police car to book her? That's the one they're talking about. State's like, we don't have that in there. No, James, that's part of your YouTube feed that you've been watching. Separate your files. You got too many things going on, James. Records from the apartment complex are not going to come in. That sucks too for us because just because we wanted to hear about all these complaints that were coming from Sarah and Brian. I find it interesting, and I think I know why, you guys. Okay, so if you're not aware, Tillwood Park Apartments was the name and owner. I don't know what the owner's name was, but that was the name that they went by back in 2020. They have since been purchased by a different property management company, and they've renamed the complex. I think what they're saying is because this other company, I don't know if they're out of business. I don't know what the status of that corporation is, but for some reason or another, they're not able to get those records now, which I find interesting because I believe that the state probably has those records. But I guess there's nothing in there that the state feels like they need to pursue. But at the same time, are we not going to hear from Melissa, the apartment manager, who had a lot of interesting things to say? If she testifies, are they going to object to her talking about the police being called at the complex? Are they going to testify about if she gets up and testifies about the complaints that they received from their apartment unit? What about Vinny? Is Benny not going to testify? Is Brandon not going to? You guys see what I'm saying? Like, how is that going to affect us if they're saying they're not bringing in the records from the apartment complex? I feel like that's a fast move by Owens. So he can say when they do try to call that witness, they're going to say, no, they can't do that, Judge, because remember, we're not putting those records on in the evidence. I don't know. I could be wrong. I'm just trying to think ahead to see I'm trying to figure out what the hell James Owens is doing. You guys, please let me know. I didn't see what somebody said something about ads. I have switched up the ads on YouTube for this particular stream. And to what I understand, you should be getting less ads today than you got before. If you are having issues with ads, can you do me a favor? And it's hard for me to find your comments in the chat, but maybe if you could email me and let me know if it's a problem now than it wasn't before, because I am trying to understand where the ads setting should be so that you guys can have a better experience while watching the trial. Because I know it's you're not going to miss anything if they play an ad. All they're doing is putting it on pause, and then you come right back once the ad is played. But hopefully there's no long ads being played. Hopefully they're all skippable. Thank you, Truth 17, John 17. Thank you for your hard work and commentary. Thank you. Thanks for being here and sticking with me through this trial. I appreciate you guys. You guys are becoming part of my family here, man. This is awesome. No, I understand. Well, I had somebody yesterday tell me that they got a bunch of ads like as soon as they logged on, and I'm like, that shouldn't be happening. Oh, you think it's because of the politics? It's all political ads? Is that what it is? I don't know. I probably should log on without being in my thing because I do YouTube Premium, and I really like YouTube Premium. The only ads I get are for Carrie's merch. Shut up, Mark. Oh, my goodness. All right. So let me go over my notes here and see if I could. Somebody help me understand. They're not placing in evidence the previous 911 calls for their incidents. They're not placing in evidence several iPhone photos from Sarah's phone. Got that. Check. We just heard the state say that they have not deposed all of the defense witnesses yet. That to me was interesting. Did you guys catch that? I'm like, oh my gosh, here we are. We are at day. I mean, we are behind the deadline. What is going on? Has anybody ever seen anything take so flippin' long? CB says that finally I get to see a picture of CB. That is so spiteful. Which part? I mean, I know you're talking about the defense, but which part? Sunday fun day. The emoji list, fan lady says. Please. I know I gotta get up on it. I gotta get up on it. We gotta get you all kinds of emojis to use for this trial. I'll work on that tonight, I promise. And CB said they're just pathetic. The defense is. Yes, yes, yes. I agree. I agree. Let's see, what else do we have here on my notes? I'm gonna do a poll and ask you guys how many times James Owens is gonna throw Margaret under the bus throughout this trial. I gotta get that up. So they were talking about these records for Sarah, these medical records for Sarah. 382 pages of jail records. The state questions the relevancy there, and they said less than 5% have to do with her mental health, which is what we're supposedly talking about here. I mean, these are after she was arrested, you guys, so it's not like anything that they're bringing in should really have anything to do with the trial, right? And it's just the defense playing games. They're just dumping. They're paper dumping. George, they still reference the 550 pages from George. They're saying that the defense said yesterday they were going to whittle those down, and they haven't done it yet. Then they said that there was the 81 pages from Sarah medical records, the treatments. This is a separate medical records for Sarah. There's 81 pages of her treatment from 2018 to 2020. The defense just gave this to the state, but this is what they're having the Richardson hearing on. They gave it to the state in images. What they do, text it to them? Like, they didn't say, here's the documents. We're going to scan them in or anything. It's like they literally scanned the images in and sent them to them. So there's no markings. Apparently they're just, I can't wait. Put them up on the screen, please. I hope they do. I hope they put them up on the screen. It sounds to me like all it is a bunch of junk just sitting up there. Just all of her records. Nothing's marked. Nothing's highlighted. Nothing. And that's what James Owens is doing right now. State wants the written rulings from this week's hearings. I want them to, please. Thank you. Thank you, court reporter. What else? The state is saying that all of these records that the defense is bringing in have nothing to do with the state of mind of Sarah Boone the night that George died. And frankly, Judge Cranick, it's embarrassing. We need a J emoji. We definitely need a prosecutor J emoji. He said, and the judge did say, COVID tests, blood tests, they're not relevant. Judge says, I want pages marked. I want dates marked. I want to know what you're doing. This is the second time the judge has, or is it the third, that's gone back to him and said, this document that you just put in, you need to go through and do your work on it. You need to quit throwing stuff at us and telling us this is what you're doing at the last hour. But Judge, I've only had 45 days. So, yeah, we feel like the states or the defense is pulling a fast one. But I don't know. Maybe did he give up? Is he saying he's not putting those into evidence? The defense wants the police reports to not be placed in evidence. And the state did not argue that. So the police reports, the Orange County Sheriff's Office work reports, everything that we've been able to see so far, I think, basically the witnesses on the stand can reference their reports when they're being questioned, but the jury is not going to be handed the reports to review in their deliberation or anything like that. Does that make sense? That's the way I picked it up. This is going to be a dumpster fire. Yes, Fawn Fargo. Thank you for your super chat, and I agree. I agree. Oh my gosh. And then they start talking about all these court orders for all Florida criminal records on George. I did a internet, like a paid search. I had this program that was like a paid search on people. And it's not the one that the police use, the FBI uses. It's just one of those that it's a cheap one. And I didn't have any records on George prior to Sarah. So I don't know what they're referencing. I heard a rumor that he may have a DUI out there somewhere, but that's the only thing I've heard. And then they want to talk about the criminal, they overruled them being able to discuss. No, they overruled the state objecting to the family law case for Sarah being brought in. So to fill you guys in on this, I will tell you somebody, SKR has some great footage or videos on the family court paperwork, letters that Sarah written, things that has happened over there, because I have not been following it. But since Sarah's been incarcerated, Brian has turned, he's done with her. And he's taken his son and they've moved away, right? So he stopped paying her alimony. And the judge had ruled that, I heard the judge ruled that he was supposed to continue to pay alimony, even though she was incarcerated. But that the custody thing, everything else was going to be put to the side until we figure out what happens in Sarah's criminal case. Is anybody, I know you guys follow SKR. Do you guys agree? Can you tell me what you know about that? Thank you, Phyllis Ann. Cooper wants to know when opening statements are. At this point, Cooper, they still have to go back and question the jury again. They haven't done their preemptive strikes. It could be this afternoon. It could be in the morning. We're not sure yet. I don't even think they're sure, to be honest with you. Yeah, the alimony debacle is pathetic. Can you guys hang on, I'm reading your notes. Hang on. What does SKR stand for? I don't know. Oh, I don't know. I would say it's not gonna start until tomorrow. I really feel like that. There's too much. I mean, it's already 10, well, it's 11:15 over there right now. So they're gonna end up going to lunch before they go and see the jury. I hope that it's not Monday. So NR says, that's what I heard. Judge ordered Brian to pay, but he hasn't been paying. That's what I heard too, NR. And the family, and Amy said, yes, what you said, the family court is pending the outcome of her trial. Okay, that's what I thought. Whew. Wow. Yeah, so the defense is saying that he's now going to be, what do they call it? A hostile witness? Because he doesn't want to pay any money to Sarah anymore. So he's going to, it's almost like they're saying he's going to say whatever he needs to do to keep Sarah in jail, which is, I don't know. Are they allowed to do that? Are they allowed to say that? That sounds kind of wrong. Definitely said he's biased because he owes her money. The judge overruled the state's request for the relevancy to bring that in. So somehow or another, that's still an open deal, and we will hear more about that. Jeez. I cannot keep up with all this. I think I've just caught us up on everything that was just discussed in that last segment. State wants more specific on the battered spouse ruling. They did that. They gave them some written ruling on that. Yeah, we've gone over everything. Holy manoli, you guys. Thank you so much, Phyllis Ann. You're so kind. I appreciate you guys. Let me go through these. Buzzman Jr., can you tell Owens is getting frustrated with Sarah? Oh, yeah. We knew that would happen. Guys, I'm telling you, I cannot wait until she blows up in front of everybody. And I feel like she will. I just hope the cameras are on it when it happens. Because, they always cut the feed or they cut the volume or the audio when they're not on session. I certainly hope we get to hear it if there is. Okay, so Michael, thank you for being a member for 2 months. He says federal benefits and 90 days in jail alimony too. Oh, yeah. Everybody's paying for Sarah, but Sarah. Unfreaking believable. I'm going through my notes right now to make sure I'm not missing anything for you guys. Alimony could go to motive for biased testimony. I mean, yeah, I get that. But I guess they're going to allow it. I guess that's Oh, also, this afternoon, I wanted to remind you guys that we may be going over to the court feed. If Trial TV Live does if they do allow the court feed again, like they did yesterday, we'll be watching it from there. So you guys can stay tuned. Don't go anywhere after this is over. So this Richardson hearing thing that they're fixing to do here when they come back. I had to Google it, but it says the purpose of a Richardson hearing is to determine whether there has been a violation of the discovery rules. I think there's been a couple of those happening here in the last 2 days in this trial, but they're just doing it on this specific evidence. Which one was this? Oh, I've already forgotten, you guys. Hang on, let me go back to my notes. I mean, the way they dumped some of these medical records, it was like, he hadn't even looked at them. He's just like, well, I don't know, just in case, just send them all of them. And then that'll give us a chance we're just going to stall. That's all this is. It's like stalling for the longer this goes on, the longer these hearings go on, the more time that Owens has. He thinks he's slick. I need to get a Daryl Brooks emoji talking about how slick they think they are. Hang on, I'm looking for my notes about where it said Richardson. Oh, it's the 81 pages of Sarah's medical records. Her treatment from 2018 to 2023. They can't just give them 81 pages and not tell them specifically what they want to look at, what they want to discuss. taking a verbal break right now. Uh, thank you guys for being here with me. I really appreciate you because I know that there's a lot of people that are streaming this today, and I appreciate you guys watching it with me here. It's so nice of you. Sarah Unintentional Boone. Somebody put that up as a. Jesus, so ridiculous. It is so ridiculous. Cookie, what? Does Owens really believe the jury will be sympathetic towards Sarah because Brian doesn't want to pay alimony to her awaiting trial for second degree? I know, right? If I'm on the jury and I know, first of all, here's what's going to happen. I don't know who's going to call him first, but when the prosecution gets up there, they're going to say, Brian, how many times did you have to do this for Sarah? How many times did you bail Sarah out? How many times did Sarah ask you for money? How many times did you give her money? How many times did you continue to take care of your son when Sarah wouldn't because she was intoxicated and called you and said, me and my boyfriend are intoxicated. We can't have him over to the house right now. Brian, how many times have you done this, this, and this? Brian, who has the health care for your son? Who pays for his clothing? Who pays for his food, his groceries? I mean, as soon as they do that, he's gonna be like father of the freaking year because he is in this case. What did they call that? What was that movie with Michael? What was his name? Mr. Mom. Was it Mr. Mom? Yeah, he's Mr. Mom. So yeah, thank you, Cookie, for your super chat, Mama. Appreciate you, babe. If we have a break, you can come on up and hang out with us if you want to. Barbara said, "Oh, Gretchen, hey, welcome in. Thanks for becoming a member." Barbara says, disagree defense is pathetic. Since consensus among lawyers rare to deny a new attorney time to prepare a second-degree murder case. Today's chaos shows why. Okay. Well, he didn't have to take the case. Thank you for your super chat.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Tony Dennison for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was adjourned by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence, Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses. and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that Jury Services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
No snacks for you, Sarah. Oh, my word. That is hilarious. All right, guys, stick with us. We might still have a feed from, I don't know, Law and Crime might stick. Now they might be able to pull the feed too. We'll see. I'm going to support Trial TV Live, though, if we can. Let's see. We'll see what happens. Oh, she's mad. She's not getting her permit. She's not getting her Pop-Tarts. She's not getting her cookies, her candy. Look at her. She's fussing. She is fussing. Get out of the way, Sheriff's Office, please. She's not happy. She's not happy, and we like that. Zephyr, thank you, Mama. Hang on. Let's get her off the screen, and then I'm going to put up your super chat. So we're definitely going to be back tomorrow. Jeez, for more hearings, not opening statements. That's not sounding very positive, is it? Yeah, I was watching yesterday. That just cracked me up yesterday. She was getting up like she was going to leave with everybody because she felt so a part of the whole process of being part of the defense and everything. And then they all got up to leave, and she wasn't allowed to. She was like, "Oh, I can't go with you." Yeah, we're going to go have a lunch. Sarah, you stay there. You'll be all right, Sarah. You're in jail. You committed a crime, allegedly.